Michael Bacina. Really excited to hear what you have to say.
Thanks so much, and thanks to our previous panel. It's never before you've got so many lawyers to mooch free legal advice from it one morning, so well done getting up early from whatever party you were at last night. Thankfully, I didn't stay up too late. I thought I might just get a quick show of hands in the room just to see how many we have in here between, if you're a creator in the space, can you raise your hand just to have a bit of an idea how many we have? That's a good number there, excellent. And who are issuers or running a marketplace kind of product for NFTs? Great. And who falls into the collector category? And that means the rest of you just came here because we're the best room? So,
absolutely the best room.
So my talk's about the lessons from NFT launches. I run the blockchain group at Piper Alderman Lawyers in Sydney, Australia, so I'm a little far from home for here. I've been in the space a bit over 6 years and been through one winter before, and I'm sure this winter will pass as well. So I thought I would try and come and give some practical notes on projects that I've seen or projects I've been involved in around the space so that it's not too doom and gloom, nightmare fuel. You know, those are the things lawyers discuss over breakfast when we're trying to puzzle out how we're going to deal with these issues. But something came up that made me, in the last few weeks, that made me think that I would repivot this little talk quickly around, Rob, get a seat. This notion of the law of the metaverse came up in a guild-on-guild dispute recently where one party said, we're not going to adhere to the terms of an agreement because the law of the metaverse applies. And I've heard about 4 or 5 people mention it, so I thought, I'm going to say something about this because I think 4 years ago I was on stage at a conference in Mission in San Francisco where I debated a very, very articulate gentleman who was running the code is law argument and saying, what the smart contracts rule, and that's it, and we don't have any time for lawyers, and too bad, you're all disintermediated. And I said, that's nice. The problem we find in the projects we see is as people get more successful or they have something to lose, they suddenly care a lot more about legal issues and compliance. So my main lesson, my biggest takeaway, is if you hear the law of the metaverse being raised, you can say, oh, I heard Mike talk about that on stage. And it sounds not at all like the decentralization maxis might present the law of the metaverse to be. So unfortunately, code is law is something that would be, personally, I think, really awesome to get to, because it would make my job a hell of a lot easier. And contrary to popular belief, lawyers don't just sit there trying to think of ways to bill people more money. But trying to get to a position where we can automate things that no one really likes to do. No one really likes to have to deal with lawyers. It's kind of like going to the doctor. When everything goes well, you don't thank the doctor. You congratulate yourself for being awesome. When something goes bad, you kind of feel a little resentful of the person who delivered the bad news. But I just wanted to go through, and I only have very limited time, so I'm going to touch on these issues at a high level. So first of all, it'll sound a little scary, but then we'll hit some practical issues around them. So even just making a little list of what I would call the law of the metaverse is a whole horrible raft of legal areas. If you were here a bit earlier, you saw the IP law panel, where we have IP and licensing tying into copyright law. A heap of contract law ties into a whole lot of NFT projects and DAOs and other things. Tax law keeps coming up recently with a bunch of projects come in my door, particularly in the last 8 months, coming in saying, we've made a bunch of money, we have no idea how to deal with the taxation of it, and there's some issues that we deal with there. Gambling and trade promotion laws are a horribly under-considered matter, particularly when you see so many NFT projects offering some kind of element of randomness. Buy this, don't know what it is yet, or win a prize, depending on if you're an NFT holder. Privacy law pops up, but generally speaking, when you're looking at art-based NFTs, it's not too bad. Securities law is always the scary one, particularly in the United States. You've heard from the previous panel about certain offshore structures that are handy, and I wish I had an hour I could go through some cool things on that. Consumer protection laws are another very underrated area, which I think we haven't seen much action. I think most of the consumer protection agencies around the world don't understand blockchain to start with and barely understand NFTs. So they haven't been active yet. Then you get into all of this corporate partnership, DAO-ish area of law that there were some comments in the talk before mine as well, which are also fascinating. And now we're starting to see the first DAO disputes arrive. Apologies for my dad joke. And what I would call NFT adjacent cases that are giving us some lessons to learn as well. And then finally, just if it wasn't horrible enough to have that kind of shopping list, then you have the international jurisdictional issues where you can take that list and rinse and repeat it in multiple jurisdictions, depending on where your holders might be. So first of all, it seems scary and it sucks. But second of all, it's a shopping list. Lists are good because you can go through them and get them done. And you feel good when you've ticked off your list. So I'm going to give just a few little pointers, hopefully on each, in my limited time. You heard some great stuff about IP previously. I think some of these are recorded. I'm also probably going to jot these down and publish it this afternoon. My Twitter's at Mike Bacina. So instead of Michael, just put Mike. So I'll post it on my Twitter if people want to have a little look through the list. But for those creators in the room, the IP and copyright point is really important. I've seen a heap of projects where they didn't handle their initial IP sensibly, and it just leaves a bomb. Getting that IP transfer, if you're an issuer or even a marketplace, clearly from whoever created, whether it's someone on an Upwork-style site for a lot of collection of 10,000s where someone's invented the art, or going to an actual artist. My sister is Vexter. She's got a great piece at 54th and 53rd. You should go see a huge mural. But getting that IP across, and then as an issuer, if you're in the issuer space, making sure you're being clear to your collectors what they are buying, because that's where, from an issuer perspective, you're going to face the liability risk, but also just forget that, the community issue of what are you getting. I think Bored Apes was mentioned, and Gutter Cats has a very similar, extremely light on terms and conditions. Those kinds of 3-clause terms and conditions are nightmare fuel for me. Most people in this space don't care and go, whatever. But getting that right is really important, and we're going to see some litigation no doubt happen when people do something cheeky. For example, under the Bored Apes and Gutter Cats terms, on my reading of it, you could buy one and probably mint another identical NFT using the same art if you want, because it doesn't say you can't. And I use the analogy of a print of an artist's work is a very good analogy legally. That's where we get the implied license idea for NFTs. So say when you buy an art-based NFT, you're only getting an implied license to enjoy it. You can't make derivative works. You can't put it on a t-shirt, unless Gutter Cats or Lazy Lions had a deal with Puma that you could. And some projects which say you can do whatever you like with them are lining up a point of danger, because if you are a holder, that undermines your right in the future if someone who owned it before you used it for some crazy commercial use that you didn't realize. Maybe they made a whole bunch of toilet seat covers, and you didn't know about it, and buy the NFT, and then suddenly it's out. Or the Seth Rogen example is a good one as well. Tax law is painful and horribly jurisdiction specific, but we're seeing a number of projects come in to say, oh, we sold a bunch of NFTs. Sales tax is really, really tricky and messy, but if you're doing issuances, you have to be really, really careful about that, because you don't want to be holding the bag for, depending on where it is, between 8 and 15% of a sale price. And I've had some clients who've just had to eat it and say, we can't figure out who was in this jurisdiction where we were supposed to collect the tax. Okay, we're just going to have to pay that ourselves. We don't think we can manage that problem. Getting around into gambling and trade promotions, when you have, there's two spectrums here. There's sort of the collector card, Pokemon card kind of model where you don't know what you're going to get, but it's recognized as not being an issue, through over to the genuine, you have a random chance. Buy this NFT and you've got a 1 in X chance of getting something really cool. Most jurisdictions have some registration requirements or licensing requirements, which are not very expensive. So it's a real low-hanging fruit on the trade promotion or gambling side to be able to go out and put something that's a raffle or random award. And that's nice and easy, low-hanging fruit for you to take care of if you're an issuer and you want to have that kind of promotion. Consumer protection law is, as I mentioned, it's not something that has come out to the fore. In Australia, we're all very used to it because we have very strict consumer protection laws against misleading and deceptive conduct. So making sure what you tell people is actually true, and a roadmap, if you're putting a project out, has a reasonable basis for planning what is to be done. Don't think disclaimers will save you, because they get read down very heavily by courts all the time. But being truthful in that communication is fine, particularly if you're going to issue an NFT that has additional later benefits. So we worked on the AO project for the Australian Open, and they put out pretty limited license. I wrote it up for them, and it was just, you get this cool tennis ball picture, and it's great, but now they keep announcing additional things. So they had competition for people to come and win a tennis clinic here, and obviously a drinks night, and then they've announced that if you're a holder of one of those NFTs, you'll get priority access to tickets at various tennis matches in the future. So the under-promise, over-deliver is another way you can practically manage your legal risk. And I think
you're out of time.
Now. So mainly in closing, if you bear in mind, anyone who tells you the law of the metaverse is that code is law, they're wrong. And I would reiterate what the panel said before about DAOs, very, very dangerous, probably partnerships. I'm a big fan of putting some kind of corporate wrapper on most DAOs because then I think you can do 90% of what you want to do without running into too much trouble. If you have any questions, I'll be hanging around afterwards. We're here with a large contingent of Australians. Come and say hello to us. Thanks so much.
Excellent. Thank you so much.